Well, greetings everyone. My name is Rick Sarre from the University of South Australia. Welcome to this little session. We're starting a little bit late, but that's okay. We will finish on 3, at which time we're apparently going to be sending everyone out to the foyer for a presentation at 3 o'clock ahead of afternoon tea. In this session we're looking at the law, and we have 2 lawyers and a psychologist to take us through some of the difficulties associated in this particular area. This is a repeat session from the one we just did, so we now know all the answers, but we're happy to share them again with you. I'm going to introduce our 3 speakers. We have Marilyn Campbell from the Queensland University of Technology. We have Butler, who is floating above Brisbane at the moment. Can we bring Des up at this stage so we can have a look at him? Thanks, Daniel. Are you still there, Des? You're most welcome to join. There he is. He's in a hot air balloon above Brisbane, and he'll be making a short presentation. In the previous session, I should say, Des spoke to the audio tape that he had prepared, which we didn't have in this session, but was shown in a previous session. It would be of enormous interest to you if you haven't seen it, or to you if you have seen it to see it again, and certainly to our 3 speakers, or 2 speakers and myself, to see that again. And the 3rd speaker is Matt Keeley from the Youth Law Centre. So those are our 3 speakers. At any time after the speeches, if there's a question that emerges, please put your hand up. There's also the Slido, which you've downloaded the app. You can always ask a question. It comes up on Fran's tablet over there, and the questions come to me. And then we'll have probably 20 minutes at the end for general discussion, at which time there will be a roving microphone. So please welcome Marilyn Campbell to the podium first.
Thank you. I only wish I did know all the answers. It would be great, wouldn't it? Okay, so this one I was told that crime and punishment is something that I totally don't agree with. So when kids are bullied, they actually fear retaliation most. But how come we have now this kind of safety culture that perhaps we want to protect kids? Even this conference is, keeping kids safe from bullying. And I'd love to have a debate about, can you actually do that? So we know from research of why are we so concerned about bullying is because we know that it is not actually good for you. It's not character building. It doesn't make you stronger. It is in fact very harmful if you're victimised or you are perpetrating bullying behaviour, or even if you're a bystander. So I was brought up in what is now named the dignity culture, where you were brought up to, look, just ignore the bullying. If you actually don't react to it, they won't bully you anymore. Just walk away. Sticks and stones will break your bones, but words will never hurt you. Toughen up, build a bridge, get over it. Now, of course, we have a safety culture. We wrap kids in cotton wool and bubble wrap. We have helicopter parenting. We have lawnmower parenting. Kids aren't to have any obstacles in the way. And schools have reacted to this by saying, no, they've got to be resilient. They've got to have some failures so that they understand what failure is and get up and get on with it. They've got to be able to sort out their own problems, but help seek as well. And I'm not sure that we're quite understanding that. I think we're giving double messages to kids. So we have a lot of protesters who says there should be a law against bullying. So if there's a law against bullying, then the police have to enforce it. This has only really been protesting against bullying since cyberbullying was possible. In my bullying research before cyberbullying, nobody was saying there should be a law. And maybe that's because if you a kid who's older and stronger, might go and punch up a smaller kid, and if you wanted to, you could have the law of assault, and you could deal with it that way. Sticks and stone, like, verbal bullying doesn't really matter. Exclusionary bullying, who cares? But once cyberbullying came in, probably because we weren't brought up with that, then it's really scary for us, and it is 24/7. So before we actually decide, should there be a law against bullying, we really need to look at what are the purposes of the law, and will we reduce bullying if we make a law against it? Well, the first part of the law, for criminal law, is actually punishment and retribution. Do we want that for our kids in a legal type of sense? Most schools look at exposing those kids who are perpetrators as a deterrent for other kids. So if you do this, you'll be kept in at 3 o'clock. If you do this, you'll write out these lines. And therefore the other kids all hear that, and so therefore they don't do it. Bullying isn't quite like that. Or you can use civil law for compensation. You can sue a school. I've been expert witness of looking at schools' policies to say whether or not they followed them, whether the policy was a reasonable policy for the school, and whether the school provided evidence that they had followed that policy. Or it could be that you're using the law to say there's a moral standard for society. So, for example, in New Zealand, they have a law against parents smacking their children. It's not actually enforced, but they wanted it as a law to say, in general, this is how we think parents should behave. But for schools, it's mostly the influence on your policy and your prevention of bullying policy. Thank you.
Thank you, Marilyn. Our next speaker is Professor Des Butler from the Queensland University of Technology Law School. And Des prepared a little 9-minute video which was shown earlier this morning, but we didn't see it in this session. And if you've seen it before, it's worth seeing again. Essentially, it says, anyone who's worried about the law being involved doesn't realise already that the law is heavily involved, both the civil law, the criminal law, and if you're talking about anti-vilification and anti-discrimination law, is a combination of both. You've seen Des hovering in his hot air balloon. I'm looking at Daniel. We're going to play the 9 minutes now, and then I'm going to ask Des to come in at the end of that to take us through some of the issues associated with some anomalies that occur around this country. Over to you, Daniel. Push. Here we go.
Hi, I'm Des Butler. I'm a professor of law here at QUT in Brisbane. Sorry I'm not able to join you in person today, but I'm glad I've had the opportunity to speak to you via technology. I'd like to say a few words about the role of policing and legal communities when it comes to bullying. A starting point is this question. Do we need a specific law that prohibits bullying, or Libby's law, as it's called by some? It's perfectly understandable by someone who's been the target of bullying, their family or other people, would want to look to the law as an instrument of the state and higher authority as a way of addressing the power imbalance between the bully and the target that Grace talked about. It would be nice if that was the simple answer to what's a complex problem. But there's a number of reasons why our team, Aurora, suggests that enacting a specific anti-bullying law is not the answer. First off, simply banning something doesn't stop it from happening. There's laws against speeding, but that doesn't stop people from speeding. And when we focus on bullying, we're talking about generally immature young people. There's laws against underage sex, but that doesn't stop some young people from engaging in that behaviour. And the fact that we are, in many cases, dealing with acts of immature people is the second reason. However we define bullying, and that's another problem in itself, since different researchers use different definitions, do we really want to criminalise the acts of children when there may be other measures that can be used that can be more effective? The law is a very blunt instrument to wield as the primary response to bullying. Now, that's not to suggest that the law doesn't have a role to play in extreme cases, but it's worth keeping in mind these words from the English Court of Appeal. There's no magic in the term bullying. In other words, the focus of the law is on the conduct, not on the label. So when we think about what bullies do, we can see that we already have laws that can be applied in extreme cases of bullying where appropriate. There's not been many cases of bullying that have reached the courts, but in this one, the bully tried to screw a towel down the throat of the target, amongst other things. But if that was the only thing that happened, we wouldn't need it to be repeated, which is a requirement in many definitions of bullying, for us to call it for what it was, assault. And all states and territories already have laws against assault. If instead we think about what cyberbullies do, well, they misuse the telecommunication system, whether it be the telephone or the internet, to intimidate or harass their targets. And we already have a law against that. It's section 474.17 of the Commonwealth Criminal Code. And that makes it an offence to use the telecommunications system to menace, harass or cause offence. And it's punishable by 3 years imprisonment. That section is backed by other sections in the Criminal Code which prohibit the use of the telecommunications system, including the internet, to threaten to kill or to cause serious harm, and to use the carriage service for child abuse material. And that includes videoing someone being assaulted and then posting that video online. The only problem with those sections is that they're in a Commonwealth statute, and it can get a bit wibbly-wobbly because the federal police are not orientated towards community policing. And that's really what's needed in extreme cases of bullying. That's more the job of state and territory police, which is why it's important to know that we have existing laws at a state and territory level that may be relevant. For example, in South Australia, we have section 19AA of the Criminal Law Consolidation Act, which prohibits stalking. And that involves a person on at least 2 occasions engaging in one of the prescribed forms of behaviour that are listed in the section, with the intent to cause serious physical or mental harm or serious apprehension or fear. Now, the list of behaviour includes following a person, loitering outside a person's home, and this: communicating with another person or about another person by means including the telephone or the internet or some other form of electronic communication in a manner that could reasonably be expected to arouse apprehension or fear, or acting in another way that could reasonably be expected to arouse the other person's apprehension or fear. you might see some similarities between that offence and the elements that Grace mentioned just before. There are other existing offences that can apply to extreme cases of bullying, although there are some differences between the states and territories. Once you look at stalking and these other offences and return to our original question, do we need a law prohibiting bullying? I think you can see that we already have laws that prohibit bullying behaviour. What we do need is better education of all elements of the community: young people, parents, schools, police, and policymakers of the existing laws against bullying, and a greater willingness to call on these in extreme cases. Now, that's not to suggest that there isn't work to be done. There are, as I said, differences in the laws in different states and territories, some quite significant. For example, the anti-vilification laws in South Australia have major shortcomings when compared to those in, for example, Queensland.
Oh, that's my email.
There's even differences in the stalking offences around the country, which, as we saw, is the offence that resembles research and definitions of bullying. So, it's our view at Aurora that we don't need to enact a new law specifically prohibiting bullying in the hope that such a law will end bullying. We do need to recognise there are many other measures that can address bullying more effectively. Nevertheless, we do need to recognise that there are already existing laws that are available in extreme cases. But we do need to harmonise those laws to remove these sometimes significant inconsistencies. We need to better educate all members of the community about existing laws, some of whom may be saying that we need a law against bullying without realising that we already have some. And finally, we need a willingness to apply those laws in cases where it's appropriate.
Welcome, Des. Over to you. I'm a bit worried about the fact that Halloween might still be happening up there in Brisbane. There's some ghostly noises coming through your presentation. But if you'd like to speak to that presentation and talk about the harmonisation required, thank you.
Okay, thanks, Rick. And yes, there's ghosts in the machine. What I'd like to do is just say something more about the differences between the various jurisdictions when it comes to some of these laws. And I'll focus on two in particular, the stalking laws and the anti-vilification laws. So we'll start with the stalking laws. And here's a graphic that I've done that shows some of the differences. Now, there's two slides I want to show you. Stalking, as I mentioned, has a number of elements, and I don't expect you to read all of this writing here. The first aspect of stalking is this requirement of the number of occasions and the relevant intent. And then the other is the actual activities that are prescribed. So, as I say, I don't necessarily want you to read that writing. The top two I've put in blue are actually addressing the notion of whether the conduct needs to be on more than one occasion. And you can see the top row has those jurisdictions, including South Australia, which I've coloured red for you in that first column, that requires two or more occasions. The second row, Queensland, Tasmania, you can see can have the offence committed on only one occasion if it's a protracted behaviour. So there's a difference between the states and territories there. The second band of rows are the black writing, and that's addressing the intention and what type of intention is required, whether recklessness is sufficient, and so forth. And as you can see, there's quite a variation between the different jurisdictions. There's not a uniform approach. And then finally, the red writing down the bottom there is addressing the issue of whether you've got to prove actual harm. So was the target, did the target actually apprehend or fear harm? And you can see there's a variety of different approaches there. If we go and look at the different types of behaviour that are prescribed, then once again you've got South Australia being in the first row, coloured red. And again, I'm not expecting you to read all of this writing. The words that are coloured red are the behaviour that would prescribe cyberbullying. So within the stalking offence, there are words that will pick up cyberbullying behaviour. Now, you may have seen in the media recently that New South Wales was reported as having introduced new laws to ban cyberbullying. Well, actually they didn't. What actually happened was that they tidied up the language of their stalking offence to make it clearer to that the offence covers cyberbullying. And it's this one here, if my cursor will help you. I actually don't know if it's coming in, not that it matters. You can see the sky blue in the third column, which refers to communicating or otherwise approaching a person using the internet or any other technologically assisted means. And so all they've really done is just tidy up the language. And as you can see from the other rows that are coloured red, they were actually doing nothing that other states and the territories hadn't already done. You can see a variety of different behaviours covered. If we turn to the vilification laws in the various jurisdictions, the blue rows, the top three rows, show whether this behaviour, which is really about hate speech, that's what we mean by vilification, whether it's a civil thing or just a criminal thing. And then in red, those rows show the grounds on which someone has grounds for complaint. Now, all jurisdictions, bar the Northern Territory, outlaw vilification on the basis of race, but there's a variety besides that. And you can see that when we look at South Australia, then there's some serious shortcomings in South Australia compared to other states when we look at the laws against vilification. The last thing that I wanted to note is the results of a study that we at Aurora did a little while ago, and this was a study of awareness around the law. And it was a study of Year 10 students, 535 Year 10 students, and their teachers, 251. And you can see that there was some rather surprising and not very pleasing results around awareness. 43% of students and about 70% of teachers either had no idea or an incorrect idea about the potential for existing criminal laws to apply to cyberbullying. Only 25% of students and 14% of teachers correctly answered that a parent can't be made to pay monetary damages to the victim of their child's cyberbullying. About 62% of students, but only 34.7% of teachers correctly stated that a parent of a child cannot be fined or imprisoned for their child's actions. When it came to vilification laws in Queensland, a relatively high group of 45.4 of students and 64.5% of teachers correctly identified the grounds. But when it came to South Australia and Western Australia, you can see the figures there are very low, 4% of students, 6% of teachers in South Australia, and in WA, no students, and 15% correctly identified the relevant ground as being only race. And also worrying, when it came to the duty of care, 69% of teachers either incorrectly stated what their legal duty required or had no idea, and that was 10% had no idea. So the point that I made in that video was that, yes, we have these existing laws, and it's understandable that people would want to look to the law as being a way of addressing this imbalance we talked about between the perpetrator and the target of bullying behaviour. But in saying that, it would seem to be the case that many, most, maybe all of them are doing so without realising we already have laws that will do the job and that we need this greater awareness of the existing laws and a willingness to use them where it's appropriate.
Thank you very much, Des. If you can hold on there. Oh, let's applaud Des. Des, there was spontaneous applause there for you, so there you go. That was wonderful. If you can hang on there for the next 20 minutes or so, we'll come back to a round table. Our third speaker today is Matt Keeley. Matt comes as a practising lawyer, practitioner with a lot of experience in relation to young people in the law, Director of the Youth Law Australia. So Matt, over to you.
Thank you, Rick. I too am somewhat concerned about the creation of a new criminal law covering bullying. This is because as adults and educators, we often already engage entirely inappropriately with our students when working in the long shadow of the criminal law. Let me tell you about JC. JC is a young man who was prosecuted earlier this year in the New South Wales Children's Court. But in my mind, this is really a story about lawyers and educators. Before I go any further, may I ask who here is already aware of JC's case, which is formally known as P versus JC, or lawyers often say P and JC? Has anyone heard of this case? No one's heard of it, it seems, and we'll come back to that fact a little bit later. JC was 16, and he was in an intimate relationship with a young woman, also 16, who becomes the complainant in the prosecution. So we will call her complainant. JC and the complainant had intercourse during September 2017. On 12 October 2017, the complainant spoke with her deputy principal and stated that she never agreed to be recorded whilst having intercourse, nor did she consent for any video of her having intercourse being sent to anyone else. Yes, this is an intimate image abuse case, but the lessons from it, I believe, are relevant in the broader cyberbullying and bullying contexts too. On the same day, the Deputy Principal interviewed JC. The Deputy Principal's written statement was evidence for the prosecution and referred to in the Children's Court's decision. And I quote from the Deputy Principal's statement. At some length, so do forgive me, but it is instructive. I called for JC to attend the office of the Deputy Principal to speak to me about this matter. I said, "Do you have inappropriate material on your phone and you've sent it to some of your mates?" He said, "Yeah, I do." I said, "You know that's illegal. I'm going to have to speak to the police." The Deputy Principal goes on. The following day, I spoke with Detective Senior Constable DS from Local Area Command. And later in her statement, on the following day, I spoke with JC in the office area. I said, "The police are coming. Do you want me to contact your parents and get them to come in for the interview? Or you can choose to have me or another teacher in there for you." He said, "No, I'll have you in there with me." I said, "So mate, did she know that you were filming it?" He said, "No, she didn't, no." I said, "So how does that work?" He said, "Do you really want to know?" I said, "Well, yeah." And of course, at this point, there's a description of the mechanics of how JC filmed the intercourse without the complainant's consent that I won't elaborate on. The Deputy Principal goes on again. "Detective DS and Senior Constable TW arrived at my office. I have a conversation with them. JC returned to the office area and he took part in an interview with the police whilst I was his support person. During the interview with police, with the Deputy Principal as his support person, JC again made admissions which, barring any irregularities, constituted proof beyond reasonable doubt of the offences of which he would subsequently be charged. But the issue was barring any irregularities. Unfortunately, there were irregularities in the ways in which the interests, rights and well-being of the complainant and JC were dealt with. In the words of the President of the Children's Court of New South Wales, what occurred in this case was wrong on so many levels. The President excluded from evidence JC's admissions and acquitted JC on all charges. The President noted that the Deputy Principal and the police officers were just trying to do their best in the circumstances. But he noted at least 5 ways in which the procedure of schools in interviewing students who may have committed a crime is occurring in a way in which he described as in a completely unfair way. And that list of 5 was not prescriptive. He actually didn't want to go into too much further detail because he really did believe that the Deputy Principal and the police officers were just doing their best. The President found the Deputy Principal failed to call JC's parents in advance of interviewing him. The Deputy Principal failed to have a person present who could protect him from making fatal admissions, who would presume his innocence, importantly, and respect his right to silence. The President found that the police investigation would in fact not have occurred but for the DP's or the Deputy Principal's unfair interview. The President found that the police failed to comply with a protocol between police and legal aid to provide an opportunity for JC to ring legal aid so he could take advice. This is a New South Wales case, of course, and whether there is such a protocol in existence in South Australia, I can't attest to. Finally, the Deputy Principal did not discharge the duties appropriately of a support person during the police interview. So how has this outcome been positive for the complainant, JC, and indeed the Deputy Principal? It clearly hasn't been. And I guess in every way, it's an example of what's been said many times in the conference today, at least that I have heard, is that sometimes the adults are making the situation worse. I think in particular of the complainant and the upset that she must have felt at this failed prosecution. I also asked myself the question, was she a willing participant in it, or was this referral to the police automatic? I don't know the answer to that from this decision, but they are certainly live questions every day in schools around South Australia and Australia. But the President was right. The Deputy Principal and the police were acting in good faith, clearly. So what went wrong from a legal, systemic standpoint? I believe lawyers have failed educators in the knowledge translation space. You might recall my earlier question about how many of you know about this case and the lessons it can teach us. And fair enough, it's a fairly recent New South Wales case, but how many of you know about similar cases in South Australia in which evidence has been held inadmissible for similar procedural irregularities? Why is it we don't hear about and learn from the outcomes of any of the interactions re bullying that our students have with formal legal processes, whether they're the negligence cases Marilyn referred to earlier or involvement in the criminal laws that Des referred to? We don't. Where are our departmental lawyers getting that information out to us in ways we can understand and apply? Like Wendy in the opening plenary today, legal practice wisdom needs to be disseminated. And as with Wendy's work, I believe the starting point is human rights. Children's rights, to be exact, the Convention on the Rights of the Child. Lawyering that can wisely navigate the rights, interests and responsibilities of bullies, victims, people who are both victims and bullies, teachers, deputy principals and principals is sorely needed. Earlier today, Des opined that we need a willingness to apply existing laws in cases where it is appropriate, helping teachers, administrators and others to determine when it is appropriate to use different laws, and I emphasise different because I believe we are not utilising the civil and administrative legal options available appropriately and often rushing too far headlong into criminal law responses. So when it is appropriate to use different laws is precisely where we need our lawyers to be heard and to make a positive difference. In particular, when not to rush to criminal law responses as the first option, and how to ensure that both victims and perpetrators, both children, that their rights are respected. Thank you.
Before we go to a more generalised hands and a round table, questions come through from Slido. That poltergeist is back. I'll try and speak more slowly. Questions come through to Slido specifically for Marilyn in relation to whether or not a little bit of bullying is not a bad thing if it's going to stimulate resilience. Life can be pretty shitty. It was the kind of little cartoon, I think, of the cotton wool. Marilyn, how would you respond to an idea that maybe a little bit of give and take here rather than a zero tolerance approach is not a bad thing for resilience building?
I totally disagree. When you have a person, when you are hurting a child, there is no room for saying that that's a good thing. Yes, you giving a child a ribbon every time they enter a race, even though they come last, I think is a stupid idea. But hurting a child, saying that a child should be hurt and shamed and humiliated, I would never, ever say that that's a good thing. It is not character building. What doesn't kill you doesn't make you stronger. No, not at all.
And just going back to the next Slido question, which I suppose can go more to the lawyers and then maybe back to Marilyn later, a human rights approach. Obviously, Australia has signed up to some human rights conventions on the rights of the child, etc. Matt, do you want to comment on taking a broad human rights approach in relation to bullying generally? Then I'll come to Des.
Thanks, Rick. Yeah, the approach that Youth Law Australia urge consistently in this space is informed by the Convention on the Rights of the Child, and it just so happens we're, I think, the only legal practice in Australia that is accredited to the United Nations as a specialist in child rights work nationally. There are 4 key principles that underpin the Convention, with best interests being a very important one: non-discrimination, participation, we've heard a lot today about the voice of children, and survival and development. In respect of participation, it's most important, and the literature suggests that you can't really arrive at a decision that is in the best interests of children without talking to them. And I did frame the question during the presentation: was the victim of the image-based abuse in the case I mentioned consulted in the decision to refer the matter to police? We would never do that to an adult victim of domestic violence. We know what current practice is. We know what practice has been for the best part of 30 years, that the victim determines the response and is provided with all necessary information and advice to enable him or her to give consent to that response. So the child rights approach is absolutely core evidence. We've been talking about evidence base. We've signed up to it. We need to communicate with the young people who are involved in these matters, both the bully and the victim. we can't take a punitive approach to the bully just because they've done something or are alleged to have done something bad. That would be to infringe one of the other principles I mentioned, which is discrimination. The discrimination is not permitted on any basis, and behaviour is one of those bases. So just generally, I think, Rick, I believe that the Convention and a rights lens, focusing on the rights and interests of both victims and bullies, is incredibly important to inform the legal information, if you like, that can then inform policy, procedures and practice. And Marilyn, in the previous session, said that she felt that the law's greatest influence in this area is to influence policy. I agree wholeheartedly, but I would go further to say that lawyers need to influence the procedures that are undertaken and also daily practice. And we need to get our departmental lawyers probably working in schools alongside people, talking to people like us, learning about the Convention on the Rights of the Child and taking those types of approaches.
Thanks, Matt. Before I throw that question to Des, if anyone has a question, if you put your hand up now, I'll make sure that a microphone gets to you. So we'll take this one over here, then this one down here. Des, do you want to come in on that?
No, not really, Rick. I agree with everything that Matt's just said.
Okay, thank you. Marilyn, did you have any comments further? Okay, we'll take the question over here. You've got the microphone. Yes, where you go.
I do. Thank you. Just two queries where I think the law may have been taken perhaps a little too widely. There's one example I'm aware of in a local high school where a image of a girl had been circulated around the school. One boy who was one of the girl's best friends forwarded her the photo to say, are you aware this photo is going around? What are you going to do about it? And then that child was suspended and reported to the police, even though he was the best friend of the child, or to the girl. Coming back to, was the girl consulted as to would that boy seem to be a bully, or was he operating in her best interest? I guess there's one query. But the other one is a case that happened 2 years ago. I'm well aware of from a lawyer that I'm friends with. 16-year-old girl, 17-year-old boy, consensual sexual involvement. He had photos on his phone. He then turns 18. He was picked up for some other case. He was then charged with child pornography. He was convicted. He was then now on the child sex offenders register for X amount of years or forever, whatever the case may be. One of those instances, again, where the law is basically not supporting the children. Just interested in your comments on that. Thank you.
Matt, I think you've said the law is a blunt instrument. Do you want to comment on both those instances?
I'm happy to. I'm happy to defer to Des first if he wants to.
Des, do you want to deal with one or both of those instances particularly?
Yeah.
One involving the young man forwarding the photograph in what he said was her best interests.
Yeah. So did I understand that in the first instance, who was the one that ended up? Was it the boy that?
Yeah, the forwarder. The forwarder was then reported by the recipient.
Right. Well, it does sound like things can. It was true what I said. I think the law is a very blunt instrument if that's the very first instance, and I think we do need to realise that the law ought to be only one arrow in the quiver of ways of addressing this sort of behaviour. And so I think both of those cases sound like they've had a very harsh response. It's been a very harsh response.
It comes down, if I can add my voice as a criminologist here, just to suggest that policing and discretion is essential in that regard, especially in relation to the child pornography issue that then emerged from having the telephone with the images still on there. Matt, did you want to add anything? Okay. Those are
very real situations, and we see them quite a lot. So the situation with the child exploitation material provisions at a Commonwealth and state and territories level is that it refers just to the you can refer just to the possession of images of someone who's under a certain age. The ages can vary depending on state and territory jurisdictions. And so we are seeing a phenomenon of young people who are ageing out of the protections of the youth offender legislation and who will be charged in just this way. And another example of the first scenario, a father was charged when he went to a police station having secured some images off his daughter's phone, and he was going to the police to report the image abuse that was occurring to her and got charged for having the images on his phone. So this is why I caution about too ready engagement with the criminal justice system. I think it would be useful to have a discussion at some point about the rules that apply to when you should report to police and when you should not, and the law that applies. And that might be something, Rick, that people might benefit from that discussion.
I see we have probably time for two questions. I saw a hand down here. Wait for the microphone. It's moving towards you quickly as Fran leaps across the room. And then a question over here might be the last one. Yes, that's you. Yep.
I'm a deputy principal in a school and have dealt with a similar situation. I don't understand why the deputy principal in New South Wales wouldn't seek legal advice from her department, as I would. You just ring the Independent Schools Board and we've got 2 lawyers and we take instructions from them. I think that would be the wisest decision to make as a leader in any school.
Matt?
Yep, I entirely agree. I was in discussion with, I have been in discussion over many years with various departmental personnel, and there is a belief that the moment a criminal offence or a suspicion of a criminal offence rears its head, that you must report to police. That is out there. And in some policy type documents, that sort of message is contained. As a matter of law, it's wrong, at least as I believe in South Australia. There used to be an offence called misprision of felony. It doesn't exist in South Australia. That's the offence which says if you don't report a crime, you've committed an offence. It follows, therefore, that it's a different type of decision making that is called for when deciding to report to police. In New South Wales, misprision of felony exists in a codified form, section 116 of the Crimes Act, and even then there is an exception if you have a reasonable justification for not reporting. And I would think that talking to a victim of an offence who then says, actually, I've been fully informed and I would rather not be the subject of a prosecution, would be a reasonable justification for not reporting to police. So yes, I agree, we need to get departmental and education lawyers more involved, but I do caution that even some of they have been propagating some of the nonsense about reporting to police over the past decade.
And if I can just add to that, and Des might want to come into here as well, if as a result of what I think we can say are I was going to use the word ridiculous, I'll use the word ridiculous, interpretations of the law by police officers who believe the strict letter of the law has been broken, and if they use their discretion unwisely, they'll be criticised. Some school administrators might say it's simply not worth the effort or the damage that could be done, not only, of course, in the specific situation, but reputationally to the school as well. So you can see some temptations of school administrators not wanting to go down that particular path. All I can say is the dialogue that needs to happen between school principals and Crown Law advisors needs to be strong. Coming from a former government lawyer, you'd be nodding your head as well, Matt. Okay, we have a question over here, Fran, if we can get the microphone to the young lady smiling at you, now laughing at you. Oh, Des, did you want to come in on the end of that last little discussion about, just pausing 2 seconds?
I think it's the case to better education all the way around, and better communication, better education.
Thank you. Okay, question.
I think we've covered a little bit as you've been speaking, but my question then is there some, and Fran might know better with the Education Department, is there something that can be set up, because we're coming across these kind of things more often now? Is there something that could be set up where a legal team has this explicit information for leadership, like the deputy principal situation, that you talked about before, is there something that's going to be embedded in schools, because it is becoming more common to have to deal with certain things?
Law reform and harmonisation, perhaps I'll go to Des first, just in relation to the imperative of law reform, explanation, clarification and harmonisation. Des, then I'll come back to Matt.
Look, this is the core theme of all of this. We have to get the laws consistent. We have to get people understanding what those laws are and when it's appropriate. I mean, that was a big point that I was trying to stress, is that the law is there, but it's got to be just one in the range of things, and everyone ought to realise that there is this range, and when is it appropriate to do which thing, and whether it involves developing some sort of protocols for the order in which you address, or that you take in addressing these things. But something like that would mean that when you have these sorts of cases, these extreme cases, you don't go straight off to the police and have the police get the wrong police officer, who then doesn't exercise the discretion where it ought to have been and sensibly ought to have been exercised in order to come to an appropriate conclusion.
Matt, or Marilyn, or...
I think what the lesson is for all of us is we shouldn't have to rush. I know that in schools we are so busy that there's no time to do anything, but we know that our responses to any kind of bullying could be harmful as well as do good. So what we've got to do is we've got to take time. Parents come to us, say, my child is being bullied. You just say, tell me about it. Do I have your permission to talk to your child about this situation? It's now Monday morning. I don't have any time the rest of the week. Can you come back either on Monday, or can I give you a call on Monday, and give yourself time to think about it, what you're going to do in that situation. And I think you need to give yourself time that these types of, well, for any kind of bullying, it's got to be repeated behaviour usually. So therefore, this isn't an emergency that you've got to do something in the next 5 minutes to keep the child safe. If it is, then of course you do something immediately. But in most cases, this has been going on for a long time. And I think we should give ourselves time to make good decisions.
Let me conclude this with one more question that came through from Slido, and it might be a little segue to what Marilyn's just said about some activities being counterproductive. This last question was looking at the evidence. Is there evidence, I'll look particularly at Marilyn, that people who are bullies go on to longer term offending careers? What's the evidence that emerges in relation to that?
I will always say that bullying is a behaviour. We do not label people as kinders when they have kind acts. We do not label a child as a bully, because it's a behaviour, and I really think we've got to watch our language. What happens is that most kids try on bullying behaviour when they're about 10 years old, and then when they go to high school, because we've disrupted their social order and they've got to find their way back again. Most kids do not persistently perpetrate. Most victims, I just broke the rule. Most students who are victimised are not persistently victimised. A small percentage are. But when we're thinking of our students, they can make mistakes. Growing up in Australian culture is really hard. G'day, you old bastard. Whoa. Was that terrible and awful? Look, he's smiling, he's happy. Like, we grow up in a teasing culture. And we've got to teach our kids what's this friendly teasing, and they've got to try, and they make mistakes. And they sometimes are very afraid if there is a person, a student who is a persistent bully, that if they don't join in, they might get victimised as well. So we've got to treat it as a behaviour that needs to be changed.
Thank you. Now, we've run out of time. That last answer and that last question does give me a chance to put my own 2 cents worth in as a criminologist. And that is to make this observation that allows me this particular observation, that is, long-term criminal careers are usually sparked by the depth to which a young person will find him or herself in the justice system as a young person. So we have to be very, very careful in relation to what extent, even with the greatest temptation and the greatest impulse to penalise and to be retributive in relation to some dastardly behaviours, let's not forget that the further you draw that particular offender into the criminal justice net, the greater the likelihood that those behaviours will continue into adult life. So I'll just add that as a kind of a little segue to what Marilyn's just said. That brings us to 3 o'clock. Helen Connolly is about to present something in the foyer. Would you thank once again Des and Matt and Marilyn for this excellent presentation?